We're live. Are we live, Hernando?
Yes, it says we're live right now, Judge.
Okay. All right. Ms. Rain, if you go ahead and announce the cause number and the case that you're here on.
Cause number DC 1912900, Jill Grigsby Murphy versus Eddie Cruz, Rosalinda Vasquez, and Kiana Allen. I'm Nancy Rain, and I'm here for defendant Rosalinda Vasquez, the movement on the motion for summary judgment.
Sounds good. Let's go ahead and get started.
Your Honor, this case involves a four-vehicle motor vehicle accident that occurred on August 26, 2019. It is alleged that plaintiff contends that my client is Rosalinda Vasquez. My client contends Ms. Vasquez struck co-defendant Cruz's vehicle. Co-defendant Cruz struck the plaintiff's vehicle, and co-defendant Allen struck, I'm sorry, let me restate that. I think I didn't say that correctly. Plaintiff alleges in her petition that my client Vasquez struck Cruz's vehicle, and Cruz's vehicle struck plaintiff's vehicle, and Allen's vehicle struck plaintiff's vehicle. Your Honor, we presented our motion for summary judgment in that there's no evidence that my client, Ms. Vasquez, struck the plaintiff's vehicle. And in fact, there's overwhelming testimonial evidence that Ms. Vasquez did not collide with plaintiff's vehicle. We have, Your Honor, the testimony of Officer Edward Lofton, who is the investigating police officer. He stated in his police report that's attached to the motion, as well as in his deposition testimony, that Vasquez was not at fault in the motor vehicle accident. In fact, Officer Lofton goes one step further and states that plaintiff is at fault in the motor vehicle accident for taking faulty evasive action. Officer Lofton's testimony and investigative report states that the plaintiff struck Allen's vehicle, then the plaintiff struck Cruz's vehicle, and then the plaintiff struck my client, Ms. Vasquez's vehicle. Co-defendant Cruz's deposition was obtained. Mr. Cruz stated that the plaintiff is at fault for striking Mr. Cruz's vehicle. Mr. Cruz also goes one step further to say Vasquez is not at fault for the accident. My client, Ms. Vasquez, was deposed and had the opportunity to be cross-examined by counsel. And it is Ms. Vasquez's testimony that her vehicle was struck by another vehicle, and Ms. Vasquez did not strike plaintiff's vehicle. Plaintiff's deposition was obtained, and the plaintiff testified that her vehicle was struck from the rear. However, there is no testimony from the plaintiff or anyone in this case that Ms. Vasquez struck the plaintiff's vehicle. So, Your Honor, this is not an issue of whether or not the plaintiff's vehicle was struck from behind, although that is also disputed. The issue is there is no evidence that my client, Ms. Vasquez, struck the plaintiff's vehicle. The plaintiff cannot identify Ms. Vasquez or Ms. Vasquez's vehicle as being the vehicle that struck her vehicle. So for those reasons, Your Honor, we have asked the court to grant our traditional and no evidence motion for summary judgment.
Yes, ma'am.
Thank you, Judge. Defendant bases their motion for summary judgment solely on the officer's police report. On the officer police report, there are several disputed facts regarding his crash incident report via the depositions taken by each party of this case. Officer stated that Unit 2, which was defendant, which was my client, was stationed in the left center lane. Ms. Murphy's testimony in her deposition stated that she was in the inside right-hand lane and never left that lane from the moment she entered into the interstate. Officer police report also says that Unit 3 was in the right center lane, which is defendant Cruz. In the defendant Cruz deposition, his testimony stated that he was in the outside right-hand lane, which was at a complete standstill the entire time. Officer also stated that Unit 4 was in the left center lane, which is also incorrect, and that is Mrs. Rain representative, which is Ms. Vasquez, who in her deposition also stated that she was in the outside right lane and that traffic came to an immediate stop, which caused her to forcefully brake. The only fact that is true in this police report is that there was faulty evasive actions taken. Based off of the deposition of each opposing party in the position in which they were driving when the accident occurred, defendant Cruz stated that there was a complete stop in the outside right-hand lane due to a truck incoming. Defendant Cruz also testified that he had no idea or any idea of knowledge of who hit who prior to his car being impacted. Ms. Vasquez said the same thing, that she was also in that outside right-hand lane and that the traffic in front of her came to a stop, and that she had to use her brakes. She also stated that she did not know of any accidents that occurred before her vehicle was impacted or before the accident occurred. Due to all of this information, our client, Ms. Jill Murphy, was unable to discuss any facts of the case with the police officer that bases his report off of a witness statement, but fails to notify or to place the witness information. Ms. Murphy was unable to provide any type of information regarding how her accident occurred because she was taken from the scene of the accident from the hospital. No witness has been named, and at this point, Judge, there is plenty of facts to determine that there was a negligent vehicle that caused this accident. My client stated in her deposition, in her petition, and throughout this entire litigation that she was in fact in the inside lane, was struck from the rear, which caused the multiple car collision. Due to this evidence and the overwhelming disputed facts, there's more than a scintilla of information that any jury would come to different conclusions. Therefore, we ask that the motion for summary judgment be struck and allow a jury to hear the evidence and to determine who is at fault and to provide the proper prayer requested.
Your Honor, if I may respond just real briefly.
Okay.
If the scintilla of evidence is that if the scintilla of evidence is that the plaintiff was traveling in the right lane, the plaintiff testified in her deposition, which is attached to plaintiff's response on page 40, line 12. The question, this is in the deposition of the plaintiff. The question to the plaintiff is, what lane were you traveling before this impact occurred? The plaintiff answered, I don't remember. I'm thinking the left lane, the left middle. So if this scintilla of evidence relies on this right lane being a discrepancy, that is not factually correct. That is not the plaintiff. That is not what the plaintiff testified to. Your Honor, there's not a genuine issue of material fact in this case. The only fact dispute is the one that the plaintiff creates on her own, where she testifies frequently throughout her deposition, about 22 times throughout, that she doesn't remember what happened in this accident. And again, we're not going to come down to whether or not the plaintiff was rear-ended by another vehicle. The bottom line is the plaintiff cannot say she was rear-ended or struck at any time by my client, Ms. Vasquez.
Ms. Mann?
Judge, the testimony of my client stated on multiple occasions that she was in the inside lane. The evidence that is disputed is whether or not there was false and invasive actions taken by my client, which is incorrect. Based off of defendant Cruz's and defendant Vasquez's testimony, the only lanes of traffic that were at a standstill was in the right outside lane that both Ms. Vasquez and Mr. Cruz stated they were traveling in, which is incorrect from the police report that has them stated on two separate different lanes. Therefore, if their false evasive action was attempted, it was attempted by defendant Vasquez, who stated in her testimony that the traffic in her lane came to a halting stop, which caused her to brake immediately. There is disputed evidence of fact that states that Ms. Vasquez had to be negligent in this accident, which caused this 4-car collision. So the disputed evidence of fact and the scintilla of fact is the fact that plaintiff Ms. Murphy was in the inside lane that was consistently moving, versus the testimony from both defendant Cruz and defendant Vasquez that stated they were in outside right-hand lane that was at a screeching stop.
Okay, I'm going to go ahead and deny the summary judgment. And I saw that there was an order submitted. I'll go ahead and sign that as well. Do you guys have a trial setting on this case?
Yes,
I believe so, Your Honor.
it's set for, I'm sorry, Ms. Rain, it's up for May the 5th of this year.
I mean, it's probably unlikely we'll actually go to trial then, but who knows? We can keep it that day if you want and kind of touch base later, or what do you guys want to do? Have you all been to mediation?
Yes, Your Honor.
Yes, Your Honor.
You all want to keep it that day, or what do you want to do? I kind of think we should keep it and just see what happens. I don't think that with the state of the pandemic, I don't think that we're going to, we're going to be doing jury trials then, but you never know. So the vaccine, we have 2 vaccines, maybe 3 now. So we'll see what happens, unless you guys really want to move it.
I'm okay with leaving it there and coming back to check on it.
Yeah,
Okay.
I'm fine with leaving it there.
You guys have a great day. Be safe out there, okay?
All right.
Thank you so much, Judge. Have a good one.
All right, thank you. Hey, so Rhonda, let me just make sure you got all of these. We had the dismissal docket today that I'm looking at. That's not the first page. Okay. So Rhonda, that first case, the Geico Mutual County Insurance Company, DC 2012430, I gave them 45 days. The next 2 cases did not show up. The American Access Casualty Company versus Nelson did not show up. I'm sorry, I have this out of order. Okay, sorry. The Geico County Mutual Insurance Company, I noticed we're still on YouTube. I'll get to that in a second. So are Ms. Norvell and Mr. Hancock, are you here for the motion to strike?
Yes, Your Honor.
Whoops. Yes, Your Honor.
Okay. All right, let's get started on that.
Well, Your Honor, I filed our motion to strike. I won't take up much of the court's time. I filed our motion to strike defendant's expert and her controverting affidavit based off the premise that real simple that she's not a chiropractor and she's not a medical or a medical doctor. She's a medical billing expert. So even though that she's testifying in contravention to just the reasonableness of the charges itself rather than the services, my interpretation is that she's a medical billing expert, and because she's not a chiropractor or a medical doctor, she shouldn't be able to testify in contravention. And therefore, I'm asking that the counter affidavit be struck.
And let me just say this, unless there's case law that I'm not familiar with, I have taken the position on all of these billing clerks who are providing these types of affidavits that I strike every one of them. And unless the Supreme Court or Dallas Court of Appeals provides contrary authority, I don't think that they're qualified to testify. So Ms. Norvell, no offense, I've been doing that consistently across the board in every case. And so I will strike this one unless there's some new case law that I'm not familiar with.
Judge, in light of the case of Gunn versus McCoy from the Texas Supreme Court,
I'm familiar with that case. I don't think it applies.
And I guess I would ask the court why it wouldn't, when it just very clearly says you don't have to be a medical professional to testify to the reasonableness of medical charges.
That's not in a counter affidavit situation, correct?
Well, Judge, yes, but then if we take it further and we go with the case out of the Tyler Court of Appeals, in Ray Brown, where a nurse.
I'm familiar with that case as well. I'm not bound by that case. I'm not going to follow it. I don't want to waste your time, Ms. Norvell. I strike these every time. I see these all the time. Just for your firm, you have a good firm. I don't think you've been in my court before on this issue, but This is my position on every case until there's contrary authority right on point from the Dallas Court of Appeals or the Supreme Court. This is kind of what I do on all those cases under Turner v. Peril. So that's the position of this court.
Just for clarification,
Sure.
without regard to the courts in Dallas County who have allowed Marilyn Pacheco's affidavits and her testimony, that's you're going to stand. I'm just clarifying, because she has been allowed in Dallas County. Her affidavits have, her testimony has.
Is she a medical doctor or a chiropractor? Is she?
No, Your Honor.
Yeah. So that's what I do on every case. I hate to have, I just want to be completely fair and transparent and say, look, this is what we do in this court. Now, if there's, contrary authority that comes out of the Dallas Court of Appeals or the Texas Supreme Court, I'll treat that differently, but this is what I do in every case. So
well,
if you
with that in mind, it explains why plaintiff's motion is basically a paragraph long.
Yeah,
I appreciate it.
Yeah, well, they probably know. Did you already know that, Mr. Hancock?
I was familiar, Your Judge, and I was more just reaching out just because I wanted to confirm that was still that there wasn't any case law, and so I guess I was aware.
Yeah, I mean, if this Dallas Court of Appeals or Supreme Court comes down with a case on point that we have to consider these types of this type of evidence in a counter affidavit, then I'll of course reconsider that. I'm going to obviously follow the law, but I believe under Turner v. Peril that these types of experts can't testify, and this is probably at least the 20th time I've heard this issue come up before, not involving you, but.
Oh no, I understand. It's what I spend most of my practice doing anymore. So I understand that.
I mean, just what I usually do, I'll, kind of, my opinion in a Turner v. Peril is that you have to do a like to like. So if you want to counter a chiropractor, you need to have a chiropractor. If you want to counter an orthopedic surgeon, you need an orthopedic surgeon. If you want to counter a radiologist, you need a radiologist.
Okay.
And that's how I do it. So.
Could I just, the point there, Your Honor, is that when we do that, the plaintiff argues they don't bill, they're not billing experts, so they can't do this. So, we get stuck in a no-win situation regardless. And it just seems that honestly, when you're dealing with that being the argument on if we get a chiropractor to testify the billing, they're not qualified to test the billing. Get a billing expert, they're not qualified. It leaves us with no options.
I don't know what other judges do, but I've had a number of cases where chiropractors have countered chiropractors, and I did not strike the affidavits. If they do it correctly, I've had a number of cases. So I don't know what other judges are doing, or if that's what you're citing to, or just what plaintiffs are arguing. But I've had a number of cases where I have not struck the affidavits. I'm just trying to tell you how I do it, just so you know in the future. And
no, it's good to know. I appreciate it very much.
I mean, I do have one firm. The guy filed like 8 or 10 of these, and each time I struck it, and each time he kept saying, I'm going to keep doing this until you change your mind. And I'm like, I'm not going to change my mind until the Court of Appeals tells me otherwise. So, and you could do the same thing. I'm not trying to tell you can't. If your goal is to try to counter in my court until there's contrary authority, that's not going to work. So,
all right, Judge, appreciate it.
All right.
Okay.
Well, thank you guys, and hope you have a great day. Hope you're safe out there. Okay.
Thank you.
And did you submit an order? Did you submit an order for me?
Yes, sir. There should be one filed with our motion.
Let me just make sure I have that. Yeah, you do. Let me go ahead and print that out right now.
Okay. Thank you, Judge. May I be excused?
You may. Have a good day.
All right. You too. Thank you.
Your Honor.
Okay. All right. So, Rhonda, I apologize. The order on this. So let me just tell you the cases that I extended. So DC 2012430, 45 days. Did you get that, Rhonda?
Judge, sorry to interrupt. You're still on
Oh, I'm
YouTube.
still